Welcome back to another edition of Between Two Fars. I'm Warnike Miller, and I am joined today by Young Cho. Currently, she is working as a senior attorney advisor at NASA headquarters. But prior to coming to NASA, she worked for the GAO, where she was a deputy assistant general counsel. Now, what that means is she was on the inside working bid protest matters. So she can really give us some valuable insight on what we need to know, what we need to think about as we're going through our own bid protests. All right, you have been asked to draft a contracting officer's statement of facts. Sounds kind of overwhelming. I mean, you've got to capture everything about this procurement in one document. What do you need to put in? What's a waste of time? How do you spend your time and energy to make a contracting officer's statement of facts that will help the agency put its best foot forward in this bid protest? Well, that's what Young's here to talk to us about today. What would you tell that contracting officer who's just been tasked to do the contracting officer's statement of facts?
I would actually tell them, work with your attorney. But we all know that we don't want the attorneys writing the contracting officer's statement of fact because it is the contracting officer's statement. So the big thing I think the first thing I think we would want the contracting officer to do is actually read the protest, okay? Because we as attorneys, and especially procurement attorneys, we're a little more familiar with the GAO decisions. We actually read them. The contracting officers may not necessarily they may have heard of these cases, but it's not something that I think I'd expect a contracting officer to do. So I would definitely tell them read the protest, because the GAO protest process, right? It's 100 days. GAO is meant to be an inexpensive and expeditious forum for protesters to file their, I don't say grievances, but they're, to file their protests, right? That being said, it's not an audit. The contracting officers may be subject to audits, and they know that's when they open their books up and they give GAO what they want, and the auditors will do whatever they need to do to perform the audit, right, as mandated by Congress. The protest is not an audit. So what does that mean? It means you may want to start off, if it's your first draft, by putting down everything that happened in the protest, but you also want to make sure that it's responsive to the actual protest grounds themselves.
Okay.
So if I have a protest challenging the evaluation and selection of a certain awardee, I may not be starting with the ASM and PSM information and the draft solicitation and industry day and everything. It's just not relevant.
They didn't bring up those issues yet. Okay.
Exactly. And if you think about how much that will take up in your contracting officer statement of facts, now you got to remember the GAO attorney is another attorney.
Yes.
That person is going to have to get through all of that before actually getting to the fact that the solicitation was issued, right? So I think that's one of the things that you want to have them think about is read the protest to see what protest grounds are raised, to make sure, okay, what the contracting officer statement includes are relevant facts.
Okay.
Now again, in a typical FAR 15 or even a FAR 16 task order procurement, you do want to at least start from when the solicitation was issued to, probably up all the way to the selection, and maybe even throw in when the debriefing happened and how it happened, because maybe there's something there that could help potentially if you want to file a request for dismissal, right? Maybe we discovered that during the debriefing there was more information that was said. But I digress.
But it gives you those important dates.
It gets you the important dates.
That has that timeline that the adjudicating attorney is going to need to look at.
Exactly. So for the contracting officer statement, always try to think about doing it chronologically from when the solicitation was issued to what happened, right? There may be areas that you want to emphasize a little bit more, and that's something that the attorney might focus you on, right? Discussions. Maybe you have an unequal discussions argument or a less than meaningful discussions argument, right? So the contracting officer statement, in a protest that doesn't have that issue may not have as much information about what happened during discussions, right? But the one that does, you may want to be explaining that a little bit more, right? The other thing to think about in your contracting officer statement of facts is, yes, you want to make sure you're pointing back to your documents themselves, but this is a great opportunity to leverage that contracting officer statement, because sometimes the documents, as clear as they may seem to us, may not be connecting the dots for a cold reader, right? You have a cold reader.
So you're not just quoting the documents and giving a citation, you're giving a narrative to help draw that picture of what happened.
Exactly. So, block quotes can be great because you can see verbatim what was said. But again, if you can provide explanation as to what happened, I think that's even better. And there are situations where, yes, you do need to, fill in the gaps and provide more context. And I think we've all seen it go both ways in the GAO cases, right? Some of them will say, this is after the fact justification, we're not giving it as much weight. This came up in the heat of litigation, but I think more often than not, you'll see a lot of cases talk about it's not inconsistent with the record, right? And it's providing additional explanation about what's already in the contemporaneous record. So I think if there are areas that you could, again, give more context to it, provide explanation in that contracting officer statement, leverage it, because the GAO will read it, right? And it's different because when it's in the memorandum of law and you're trying to fill in the gaps, it's not going to get that same level of credibility that I think that you would get if it were in the contracting officer statement of facts.
Yes.
And
the contracting officer is given a lot of weight and authority. Their opinion, their viewpoint is valuable.
Absolutely. And I will say, looking at my own cases that I've worked on, as well as just reading GAO cases, if you look to see sometimes what they reference, and you can see it, the agency has explained, and they'll have that explanation in there, and the citation oftentimes will be that contracting officer statement.
Oh. So it's very valuable as the writing attorney is adjudicating the bid protest. It gives them something to rely on and cite to.
Absolutely. Now, if that's raised in an argument, that's really more of an argument, right? And so that's why the contracting officer statement, it's such an important document. And, again, from a strategic standpoint, there is so much more we can do with it. And because our contracting officer is signing it, this is something where if it were someone other than the contracting officer, you may need a declaration, right, to fill in those gaps. This is an easier way to fill the gaps. So I think we really need to leverage it. So, the contracting officer should focus on those areas. But again, one thing to think about is, okay, if the attorney is trying to help the contracting officer fill in those gaps as well, I think they should be willing to entertain it, if that makes any sense, right? Because I don't know if there are some folks who are like, no, I just want to stick to my facts.
Right. Whereas the attorney may see some nuances in the arguments that have been raised and say, we need you to talk more about this time period. We need you to talk about the interaction or the transactions, the communications you had. And it's not a critique of the contracting officer. It's just usually the attorney seeing a bigger strategic picture for the bid protest and wanting to fill the gaps.
Exactly. And I think it's a worthwhile exercise. Like I said, that's where the GAO can look to something to say the agency has explained. Right? And without that, they may not be able to get to the decision of, well, the agency's actions were reasonable, right? That's what we want to get the GAO to. How can we get them there, right? What do we give them to say what the agent, this is what the protester alleged, and we need something in between for the GAO to come to that conclusion that the agency's actions were reasonable, right? Or that they were unobjectionable. How do we get there, in the absence of a very long, nice narrative in your record. You may have something there, right? If we don't have anything there, well, we might not have even gotten to that point. But to the extent that we've decided to defend the protest, if you need that little bit extra, it's the contracting officer statement is just a great place where you can leverage that. So,
Fantastic.
yeah.
Well, I hope from this discussion you realize your vital role in this bid protest process. We do appreciate and value our contracting officers and your insight and experience in this situation. So don't be afraid to ask questions to the attorney to figure out how to get through this complicated and important document. But remember, it's your insight and your facts that really can make the difference in the agency's bid protest litigation. Thank you so much for your time, and we look forward to seeing you again on the next episode of Between Two FARs.